speaker. Next speaker is an old friend of mine whom I have had the opportunity of uh, meeting and discussing in the past, but whom I have not met for some time in the near future, is Mr. Menaka Harankaha. He is from the senior lecturer from the Faculty of Law of the University of Colombo, and he earned his LLB from the University of Colombo and the MPhil, and he is going to speak to you all with regard to the principles of constitutionalism. And let me call upon Menaka to the stage. Menaka, who is to you?
Mr. Chairman, Mr. Tusantha Vijayamanna, Senior Consultant, and also I must say he was the Senior Academic Castle Faculty of Law very years back. And Dr. Pratibha Mahanamayava, the Dean of the Faculty of Law of the Patalavala Defense University of Sri Lanka, my colleagues from the Faculty of Law of the University of Colombo, dear participants. So, it's a pleasure me to present my paper today on the topic titled, as Mr. Tusantha Vijayamanna mentioned, Principles of Constitutionalism and Public Security, exploring a balanced approach through legislative and judicial intervention. So, I thought of doing, in fact, I did my research in the particular area, believing that not only, so don't believe that I will be presenting my this one with PowerPoint this one. So you are compelled to look at me and see what I am telling. So what, in fact, what I needed to discuss this was basically the constitutionalism is one of the basic principles in constitutional law, which mainly discuss and also mainly emphasize the importance of limiting the powers of the government. So for the benefit of those who are not so much familiar with the constitutional law, let me just explain briefly about this concept. So it is something regarding limiting the powers of the government. That means even the legislature, the main organs of the government, normally, namely, the executive, legislature, or judiciary, none of these organs or institutions are not entitled to use their power at their potential. So they must be in a position, these institutions, that is the legislature, maybe some of the parliament, or the executive, or the judiciary even, cannot exceed their given limits by the constitutions, and they must confine their all the powers within the given power by the constitution. So that is the basic idea of constitutions. So therefore, in such a situation, it is a mandatory requirement in order to enhance, protect, and uphold the constitutionalism in any country to respect the human rights and personal liberties of every and each person with the particular country. So therefore, it is an aspect protecting human rights, respecting the rights of the individual and their liberties by any organs of government, by any branch of government, in order to protect constitutionalism or the constitutional rights of the people. So that is one basic thing that we need to understand. So then what about the public security or the security of the public security or the state security? So when you understand, once you are discussing the importance of the human rights, at the same time you discuss the importance of the public security as well. So even the international conventions, which are dealing with the basic human rights of the human being of the world, very clearly provide not only the protecting of the human rights of the general public, but even it is essential to protect public security and state security in order to protect the order and peace of the country as well. So therefore, there must be a balance, as you can understand very clearly. So that is very clearly provided by even very well-known international conventions, as I shortly mentioned, UDHR, Universal Declaration of Human Rights, very clearly provided by Article 29. In short, it says, limitations as are determined by law solely for the purpose of securing due recognitions and respect for the rights and freedom of the others. Yes, limitations can be introduced. What does mean limitation? Limitations over the free enjoyment of human rights can be introduced. But this limitation must be to some extent restricted, and also the same thing is being mentioned by the other very prominent international convention, ICCPR, like this. State parties may take measures as state parties may take measures of derogating from their obligations to the extent strictly required by the exigencies of the situation. Yes, you can limit the rights of the people, human rights of the people, if the situations of the country, if there is a timely required situation in the country to limit all those human rights of the people. If the situation required, if the national security is so important to protect and secure, in that time there must be some control over the free enjoyment human rights. That is accepted norm even internationally. So when it comes to Sri Lanka, you will understand very clearly, even by the 1972 First Republican Constitution, as well as by the Second Republican Constitution, 1978 present Constitution, both constitutions, while recognizing very clearly all basic important human rights and fundamental rights, at the same time it recognizes some restrictions over free enjoyment of these human rights. So you see, even under 1972 Constitution, Article 18(2) very clearly provide there are many restrictions over the free enjoyment of human rights. So that means, in short, suppose in case a press, a company, a publisher wants to publish a paper, it publishes the paper and giving some information or idea to the society, but the government suddenly take a decision to stop that by prohibiting, by banning the particular press. So that means in that case where the particular press company blame that they are human rights for the right to information, free expressions has been violated by the action of the government would say, respond and justify their action by saying, what? Yeah, we had to do that because of the national security, because of it affects the national harmony of the people and ethnic groups as well. Suppose a fraction of the people in the society comes to the road and they start propaganda or they start some kind of protection against the government making some demands. So the government take an action by sending army or the police to the road and saying and taking some actions to stop the particular demand of the people. So the government would say, try to attempt to justify their action by saying, yes, we did so because it would affect the rights of the other peoples to move, their rights to move, free movement, their right to free enjoyment of their other rights. So because of that, they took that decision. So that is the balance what we need to decide. But once you look at our constitution, the present constitution, it also, by Article 15 very clearly, provide many and many restrictions over the free enjoyment of the human rights. So once you look at this particular section, what I need to say is Article 15(7), subsection 7 of the Article 15 very clearly provide, yes, as the above are subject, those human rights, the fundamental rights are subject to such restrictions as may be prescribed by law in the interest of the national security, public order, such and such. So that means the government can take steps, can involve with the kind of actions to stop that kind of free enjoyment of human rights for the sake of national security. And that must be done by law. So what does mean by law here? So that is the very important point I need to raise here. Yes, the government can involve with restricting the rights of the people by prescribed law. Here the prescribed law means law passed by the parliament. So that means in case where the government want to restrict some constitutionally recognized human rights to the people, so government can do by way of passing act in the parliament. So there is a one, there is a one exemption to this one, which provided by the same article as well. That is in case of emergency, where the president is given power to, after making the proclamation, once the president is given power to issue emergency regulations, those regulations also consider as what is called laws of the country. That means the emergency regulations are laws, but through the emergency regulation, if the government attempting to control the rights of the people, that can be justifiable. Right? So this is the Sri Lankan scenario with respect to this one. So now what I need to emphasize in this particular presentation is what is the present trend of the world with this respect. Is there in reality the balance between free enjoyment human rights, the liberty, constitutionalism, and the national security and public order between these two? Or whether more emphasis has been made by the constitutions and the judicial attempts of the countries to have more, to empower us more on public security rather than free enjoyment human rights. Or that has been justified not here in Sri Lanka but in the USA. So that is why I need to emphasize here. I'm not going to say that this is a completely correct phenomenon or the trend in the world, but where there we have learned the human rights and all those aspects, the particular country itself now have taken steps to control the human rights of the people, especially when it comes to which is called the enemy foreign combatant. After so-called the Afghanistan war, now the USA has decided to control the human rights, not the people of the United States, the citizens of the United States, but those who have been taken into custody as the foreign enemy combatant who battle against USA, especially the Afghanistanians and the Yemen people, and those who were detained not within the jurisdiction of the USA, but outside the jurisdiction of the USA, somewhere in Cuba or Guantanamo Bay or somewhere else. So their detention has been justified by the US President as well as by the Congress by passing the particular act in the Congress, which is called the Military Commission Act in 2006, and after that, Military Commissions Act 2009. So both act very clearly emphasize, yes, President is having the power, President is empowered to take actions, to give the power to the military commissions to act and make some kind of decisions, and even to take some decisions to detain and also the arrest so-called suspects who were taken into custody. So on what basis that can be justified? It was the justification made by the US government. Yes, we took that because according to US Constitution, it very clearly provides every human being, according to the Bill of Rights, every human being should be protected. They cannot be taken into custody arbitrarily. But all those arbitrary custody has been have been justified by the action of this particular act, and that has been justified by the US government saying, yes, we have taken this decision not against the citizen of the USA, but against those who have been identified as foreign enemy combatant. So what is the point of identifying them as foreigners and outsiders and insiders or the citizens of the country? So most of the human rights activities in the USA also now question, can we differentiate, can we make that kind of a differential treatment against foreign combatant and not giving that kind of illegal treatment or the arbitrary treatment to their own citizen? But however, that has been, what I need to emphasize is that, so when the national security is at stake, so there is a tendency in the world, especially through the actions of the USA, even the legislature willingly involved with the executive to take some decision against and controlling the rights of the people of their free enjoyment of human rights. Not only only the judiciary involved with going against that. Even the judiciary, Supreme Court very clearly pointed out in two important cases, this kind of action cannot be justified because we can't make that kind of differential treatment to foreigners while protecting only the citizen of the USA. But despite the Supreme Court decision, even after that, USA Congress has passed another act justifying the executive actions on the basis that, yes, it is very important for the sake of the security of the country, that kind of action can be taken. So ultimately what I need to say is that, so this is the trend of the world. So in case where the national security is at stake, there is a tendency, not only the executive, but even the legislature collaboratively involved with controlling all those powers, while the judiciary is being kept away. But what I need to emphasize here is that this, yes, in case where there is a real security at stake, yes, not only these three organs, but even two organs, but even three organs can work collaboratively to the extent this kind of restrictions can be defined as reasonable restrictions. So in order to identify the reasonableness of restrictions, it is not for the executive, it is not for the legislature, it is to the judiciary that power must be given, whether the restrictions made by the executive or the legislature is reasonable or not. That can be done, that must be done only by the judiciary. Thank you very much for giving your kind attention to this one.
Thank you very much, Menaka, for educating us with regard to the constitutionalism, and especially with regard to this goes back to my days in the university where I used to teach jurisprudence, and I used to talk about rights and obligations in dual opposites, where you have a right, you have also an obligation. So as you rightly said, whenever you enjoy rights, you also have an obligation, and the obligation is to make sure that the others' rights are not being violated.